Looks like we're live on YouTube now.
Yes, Chairman Miller, we are streaming live on YouTube now, and we're streaming obviously on Zoom. So we are good to go whenever you would like to convene the meeting.
Great, we are ready to go. I'd like to convene this meeting, a call to order this meeting of the Ethics and Campaign Review Board on August 19th, 2021. Can I have a roll call, please?
Yes, Chair Miller,
Here.
Member Amer. Judith
Unmute,
Amer.
Judy.
We can see you.
Okay.
I'm here.
Thank you. Member Biederman,
Here.
Member Kovnat,
Here.
Member Lujan,
Here.
Member Martinez.
Here, and I've been notified that some people are still in the waiting room.
Mr. Chair, you have a quorum.
Okay, can we go ahead and let everyone in who's waiting, and then we'll keep moving?
So Chair Miller, and I'll defer to how you would like for us to handle this. Generally, the individuals who are here for an item they raise their hand and we let them into the actual meeting. And then the other individuals stay in the waiting room. Would you like me to let everybody into this meeting and then just request that they keep their cameras off unless it's their turn to speak?
I think that's the right way to go. I don't imagine there are too many people. You know, it's a public meeting, so I think everyone should be in who wants to be in.
Okay, perfect. They still participate. It's just a different view for the meeting, but I'll go ahead and admit everybody into this room, and then again request that they keep their cameras off unless they are presenting an item. How does that sound?
That sounds good.
Okay, perfect.
Okay, so has everyone been let in, Christine?
Yes.
Okay, great. We will continue. We just did the roll call, and now on item 3, approval of the agenda. The board has been provided.
Move to approve the agenda.
Move to approve by Ms. Kovnat, seconded
Second.
by Mr. Biederman. I think we need a roll call vote on the agenda.
Yes, Member Amer,
Yes.
Member Kovnat,
Yes.
Member Lujan,
Yes.
Member Martinez.
Yes.
Did I get everybody?
No, you didn't get me. And yes,
I'm sorry, Member Biederman
yes.
and Member Martinez. Is that everybody?
I believe so.
Thank you. The motion has been approved.
Got me.
Great. Item 4, approval of the minutes of our last meeting, which was held on June 17th, 2021. Can I get a motion regarding those minutes, please?
I move to approve with just a slight correction. In 5A, the sentence says, Marcus Martinez, Assistant City Attorney, said he did have anything. There should be a not there. Did not have anything beyond what was provided in the packet.
Okay. Do I have a second?
Second.
Okay. Motion has been made to approve the minutes with a small edit, and seconded. Motion was made by Ms. Kovnat, seconded by Ms. Amer. How about a roll call vote on approval of the minutes?
Yes, Member Amer,
Yes.
Member Biederman,
Yes.
Member Kovnat,
Yes.
Member Lujan,
Yes.
Member Martinez.
Yes.
The motion has been approved.
Great, thank you.
May I raise we're not getting the chairman's vote. So
Yep. Paul, I generally don't vote unless there is a tie, so.
I should have known that by now.
That's okay, no problem. Okay, moving on to item 5, 5A specifically, which is titled Case 2021-1. This is a complaint brought forward by Alexis Martinez Johnson versus Alan Weber. I won't read the whole title there, but it is a complaint made pursuant to the rules of the Ethics and Campaign Review Board. Just real quick, as we get into this, I would like to see if there are representatives of the complainant and the respondent attending the meeting. Can I just ask real quick for anyone who's representing the complainant or respondent to identify themselves?
Yes, this is Alexis Martinez Johnson. Can you hear me?
I can hear you fine, thank you.
Thank you very much.
Hi, my name is Kate Furlick and I represent the Alan Weber for Mayor campaign.
Okay, great. I'm glad that both of you are here as we get into this. I just wanted to make sure as we proceed. So to hear this complaint has been filed. Just briefly, the complaint alleges that the campaign, Alan Weber for mayor campaign, excuse me? Sorry, I heard, okay, sorry about that.
Yeah, yes, Mr. Chair, before you get into the complaint, I would like to state for the record and inform the board that I am recusing myself from consideration of this complaint, as my partner, Kate Furlick, will be representing Mayor Weber.
Okay, understood. Thank you, Christina. I'm sorry I jumped right in and didn't give you a chance to say that immediately, but thank you for notifying us. As far as I understand, the recusal process will be that Member Martinez just abstains from participating in the discussion or any decision-making in a Zoom call. I don't know if that means she just turns off her mic and her video, and then we will invite her back in at the end of this item. Does anyone have a different procedure? Marcos, I guess I'm thinking of you. Does that procedure sound fine for you for a recusal?
Yes, and the city clerk is here as well. I think typically what we do in our other boards is the person who is recusing themselves will typically leave the meeting, and we will communicate with them as soon as practicable as to when to rejoin. But that's generally our process. Christine, did you want to add anything to that?
No, you pretty much said what I was going to suggest, was that we would have Member Martinez just go ahead and leave the meeting, and then I'll re-forward you the link to your email. Once you're requested back in, that'll kind of be your signal just to rejoin.
I will be on standby. Thank you, everyone.
Perfect, thank you. And then Chair Miller, I normally just confirm that she is no longer a participant in the meeting, which I will do so right now. She has completely gotten off the meeting. So
okay,
there we go.
Good, thanks. So the complaint before the board today alleges that the campaign of Alan Weber violated the Code of Ethics or the Election Code by utilizing taxpayer events and coordinating taxpayer resources to promote personal mayoral campaign via campaign email distribution. The campaign, you all have had a chance to read the complaint. The complaint centers on the campaign's email promoting what was called Santa Fe Cool Downs, 2 events in July of 2021, in which the city planned to open up water hoses or hydrants. I'm not sure exactly how it worked, but for people to play around in the water in a hot summer day. The complaint was submitted on July 15th, 2021. The respondent, Alan Weber, was notified of the complaint. The respondent was given the prescribed period of time in which to submit a written response to the complaint. The respondent filed a response in the form of a motion to dismiss. That response was provided to the board on August 11th, and the board scheduled this meeting to begin the process of hearing the complaint. There are no further documents in the record on this complaint at this time. For all of us, as a refresher, and especially the complainant and respondent who may not have gone through this process before, I'll just give a brief outline of how the board handles complaints. The initial step is for the board to determine the legal sufficiency of the complaint. So specifically, whether the face of the complaint states with particularity legally sufficient facts which, if true, show probable cause to believe that there was a violation of the Code of Ethics, the Campaign Code, or the Public Campaign Finance Code. So the board must dismiss the complaint if it was filed too late, as in 1 year after the events complained of occurred. 2, if it does not state a violation of the aforementioned city ordinances. 3, if it was frivolous or was filed solely to harass or intimidate. Or 4, if the board lacks jurisdiction to hear the complaint. If the board dismisses the complaint at this stage, in other words, if the board finds that it is not legally sufficient, then the matter is resolved. If the board does not dismiss the complaint, we will proceed to a hearing, and we can discuss those procedures in this meeting if it is necessary. The board will hear from the respondent and the complainant and the respondent before deciding on the legal sufficiency of the complaint. So we will give each party an opportunity to speak briefly about the complaint and their position on the complaint. Are there any questions from the board about the procedure we will follow today?
One question, Mr. Chairman. Can we ask questions of the people presenting their side?
Yes, absolutely.
Okay, thank you.
Any other questions? I'm not seeing any. Christine, will you, I know there's sort of a hand raising process or something like that. Will you just alert me if you see somebody trying to get my attention that I don't notice? Will that work? Okay.
Yes, of course. And I believe I did make you a co-host just so you could see that, but I absolutely will make sure if there's someone getting your attention, I'll let you know as well.
Good. Well, I'll do my best to pay attention to that also. Okay. Well, with that said, first among the board, is there any discussion before we hear from the complainant first and then the respondent? Okay, I'm not seeing any board members wishing to say anything or discuss anything yet. So with that, let's go to the complainant. Ms. Martinez-Johnson, if you would like to address the board, we would like to hear what you have to say.
Thank you very much, and thank you for the board in hearing this case today. Again, my name is Alexis Martinez-Johnson. I'm a citizen here in Santa Fe, and I am running for the mayoral position. While it is entirely okay for the mayor to participate in any city function, and it is entirely okay for the mayor to disseminate information to the entire city as the mayor, there's nothing wrong with that whatsoever. And he can email, he can do newsletters, and he can promote in any way that he wants, any city function. The issue and the subject matter at hand is it okay for the mayor to utilize a campaign email and his campaign logo paid for by Alan Weber and have to and he's sending it to all of his supporters, that he's going to be with the firefighters at a city event. This implies that the firefighters and the optics surrounding this is a collaboration between taxpayer-funded employees and resources with a campaign. What should have happened is the mayor should have disseminated the information to the citywide, as he has that capability, but not via your campaign email. This not only produces optics, but it also produces a situation where taxpayers are under the understanding that there's some type of collaboration. And whether the firefighters support or do not support Mayor Alan Weber, he has now provided the information to his supporters that it is a campaign function. And this is something on an ethical view that we need to be cognizant of. As a public servant, you are called to a higher standard. And this creates a situation where there is inequity. And I would ask the board to not dismiss the case. I am unaware that there is any type of statute or ordinance or stipulation that even addresses this particular function from a public official collaborating or utilizing campaign resources with the city and city employees. And so I would ask and request that the ethics board understand that this campaign is a grassroots effort. It represents the voice of many New Mexicans. And when you decide to dismiss this case, you are in fact dismissing the voice of many New Mexicans who are unable or do not have the political resources, the legal services to bring about a voice. So what is occurring here is that the Weber campaign can very easily dismiss this case because they're able to obtain legal services to erase the New Mexican voice. And so I would ask everyone here to just make sure that this race is run in an equitable fashion. And I thank you for your time.
Thank you. Ms. Furlick, would you like to speak for the respondent?
I would, Mr. Chairperson. To the board, thank you for scheduling this hearing so quickly. I think that as Alexis Martinez Johnson admitted, she does not know what provision of the ethics code was violating, that the campaign allegedly was violating, and therefore this complaint should be dismissed. I did file a response with the board, but the board can dismiss the complaint for basically one of or all three reasons that I'm about to talk about. First, as I just mentioned, the complaint is deficient on its face as it doesn't meet the standards prescribed by the ordinance that governs complaints. And that's specifically 616(3). And here the plain language of the law requires dismissal of this complaint. And I'll get into that in a moment. But second, the board's rules of organization and practice unequivocally require dismissal of the complaint. And these are rules that this board promulgated to govern the way that these complaints are supposed to be heard and considered. Third, as explained in our motion to dismiss, due process concerns mandate the dismissal of the complaint. Before I get a little more into those arguments, and I'll be brief on all of them, I want to take a step back to the purpose of the board, and that's under the City of Santa Fe Ordinance 616(2). You all are charged with enforcing the provisions of the Code of Ethics, the Campaign Code, and the Public Campaign Finance Code. And this board has a set of procedures to follow and laws to comply with. Essentially, these are the perimeter of the board's consideration and actions today. And those procedures and the plain language of the law necessitate dismissal of the complaint. And Ms. Martinez-Johnson has spoken of her mayoral campaign and spoken of, a vague alleged violation without being able to specify it. And I want to read 6-16(3), which is part of the city ordinances governing complaints to the ethics board. And it's the second sentence of that section. The complaint shall state the specific provision which has allegedly been violated. And then the sentence goes on to say, and the facts which the complainant believes support the complaint. I think that you all have a copy of the complaint that Ms. Martinez-Johnson filed. And that is, I want to turn your attention to section 3, where the complaint form asks for which specific provision of the Code of Ethics or Election Code you believe has been violated. And Ms. Martinez-Johnson writes, for Ethics Review Board to determine. So on its face, the complaint violates the ordinance, and on its face, this complaint is deficient because it does not state a claim. Second, I want to talk a little bit about the board rules. And within the authority granted to it by the ordinance, the board promulgated rules that govern how hearings will proceed. And I think as Chairperson Miller explained, this is a preliminary step in the process to determine if the complaint is legally sufficient to proceed. But under no uncertain terms, the board's rules of organization and practice require that the complaint state a particular provision of the Code of Ethics, the Campaign Code, or the Public Campaign Finance Code. And that's section D1. And those rules unequivocally provide the board, or require the board rather, to dismiss the complaint under section D4B. And the board can consider appropriate submittals by the parties. But then, as they do in this initial meeting, the rules provide that they shall dismiss the case if the complaint does not state a violation. As I said before, Ms. Martinez-Johnson's complaint does not state a violation, and the language shall state a violation and shall identify the specific provision that she's alleged the campaign to have violated is a mandatory provision. So this board doesn't have discretion to hear the complaint. The only action the board can take is dismissal, because both bodies of law, the rules and the ordinance, require a valid complaint. Lastly, I'd just like to talk about due process. And actually, before I do, Ms. Martinez-Johnson is running for mayor. She should be familiar with city ordinance and the board rules here. And despite what the alleged familiarity, she has decided to basically say that a lawyer is undermining taxpayers or the citizens of Santa Fe. But Ms. Martinez-Johnson needed to do more and make a specific allegation against the campaign. In terms of due process, the complaint should be dismissed because allowing it to proceed would violate the campaign's right to due process under the US Constitution and the New Mexico Constitution. And the right to due process, as all of you know, ensures that judicial, or in this case, a quasi-judicial body, meet a basic level of fairness in their procedures. And so without stating a claim, first, Ms. Martinez-Johnson is attempting to deny the respondent to meaningfully respond. And second, is that the right to due process requires that there be an impartial tribunal. So when a body such as this board acts as the decision maker, impartiality is an essential guarantee of due process. And so the complainant has asked this board essentially to act as both prosecutor and judge, and that is inappropriate. So it's not only inappropriate for Ms. Martinez-Johnson to ask the board to fill in the gaps of her complaint, it's impermissible for the board to actually do so. The only permissible remedy here is for the board to dismiss the complaint. I will let any of the board members ask any questions.
Thank you, Ms. Furlick. Well, we will open it up to the board if there is, if any board members would like to discuss or make comment or ask any questions of the complainant or the respondent, please feel free. Mr. Biederman.
Thank you. My question is for the respondent's attorney. And it is this. How would you respond to the idea that by describing conduct that allegedly violates certain provisions of, say, the ethics code for the city, that even though the plaintiff has not, a complainant has not actually designated that section, that satisfies the requirement?
So what is the argument that just because there are factual allegations that have been made, regardless of whether she's stated a specific violation? Is that the question?
Yes.
For the reasons that were just discussed, Mr. Biederman, the ordinance and the board rules require that a specific provision be identified. And also because Ms. Martinez-Johnson is asking this board to take a set of facts and then try to find a violation. And that's a violation of due process. And that forces the board to then become a prosecutor in this process rather than the impartial decision makers that they should be.
Well, then following up on that, suppose someone files a complaint in magistrate court alleging a breach of contract, but doesn't know the term breach of contract. Looking at the forms that are approved by the state Supreme Court, that complainant isn't ruled out just because the magistrate judge has to identify what the law is. So is this board in a position of being more akin to a people's court, as the magistrates like to refer to themselves, than it is to a more formal proceeding, such as a higher level of court?
Understood. And, you know, many of you are lawyers on this board, and this very much is similar to a 12b6 motion for failure to state a claim. Frankly, Ms. Martinez-Johnson hasn't made a claim. I don't know, and I don't think this board knows what she is alleging Mayor Weber violated. And she herself admitted she doesn't know if he violated the law. I think that Ms. Martinez-Johnson is using this as a mouthpiece because she is also running for mayor.
Thank you.
A point of order there, Mr. Chair.
Yes, Ms. Lujan, go ahead.
With all due respect, Ms. Farrell, you're stating an opinion there and not sticking to the facts of what you were trying to do through this process. Thank you, Mr. Chair.
Thank you, Ms. Amer.
Yes, Ms. Furlick, I have a question. Do you think that this body has the authority to dismiss the complaint without prejudice and ask the proponent to amend the complaint and refile?
That would be up to the board. It certainly could be a recommendation. However, I do think that the ordinance and the board rules just require outright dismissal of the complaint.
Thank you.
Thank you. Thank you. Ms. Amer, were you finished? I'm sorry to interrupt.
Yes,
Okay.
I'm finished.
Ms. Lujan?
Thank you, Mr. Chair, and thank you, Judith, for that, for stating that, and also thank you, Paul, for what you said as well. The question I have, if statutes exist, I mean, is that enough? Is that not enough for us to take action upon? And I understand where your argument is with due process, but if this already does exist, are we being negligent by not, maybe if not making a ruling, but giving an opinion, which is under our scope as a board to give to Ms. Alexis Martinez? Mr. Chair.
Ms. Lujan, I understand that to be a comment rather than a question, but if you were looking for an answer, did I read that correctly? It was a comment.
Partially, Mr. Chair, yeah, partially comment, possibly. I mean, we're trying to figure this out, but
yeah.
And what part of the law? I'm the only one on this board, Ms. Farrick, who is not a lawyer. However, I have experience in campaign law and have worked in campaigns, and looking at the evidence and the facts here, should we give an opinion here rather than give a ruling? Would that, I understand you said that we don't get into the confines of due process and not violating a due process, because I do understand their arguments, and I'm at odds with it, because if we know that this information or rule or exists and we don't act upon it, are we not are we acting correctly, I guess, and in the best interest of the public?
Thank you, Ms. Lujan. Any other comment from Ms. Kovnat? Are you ready? Yes, Ms. Kovnat.
Yes. I've been troubled by the complaint and the able argument of respondent for the last couple of days. And the argument convinces me that this complaint should be dismissed, but without prejudice, giving an opportunity to the complainant to amend the complaint or file a new complaint that complies with our rules of procedure. So that's where I'm coming down on this.
I saw Ms. Amer's hand first, so Judy, please go ahead.
Thank you, Justin. I agree with Ms. Kovnat that Ms. Furlick makes a very persuasive argument to me about due process, and I agree that it would infringe on the board's impartiality for the board to be framing what the potential statutes are that were violated. And I agree with Ms. Kovnat that the proper thing to do in this case would be to dismiss it without prejudice and allow the complainant to comply with the ordinances regarding pleading of complaints and specify which sections that the complainant believes were violated of the city code by an amendment.
Mr. Biederman?
Thank you. I am inclined to think that there's been enough stated in the complaint from a layperson, and I don't think we have to worry about due process in these circumstances, because the Supreme Court has already approved magistrate complaints that are less detailed than this as a form, and if the Supreme Court wouldn't approve something that deprived people of due process. But that said, I would suggest we go into executive session at this time to deliberate this among ourselves as we're entitled to do under the Open Meetings Act. In fact, I'll so move. And that was on our agenda, that we could go into executive session.
Correct. Okay, well, we have a motion on the table to move into executive session for deliberations. Do I have a second to that motion?
Second.
Just one seconded by Ms. Lujan. Ms. Amer, do you have discussion on the motion?
I believe we need to cite to the section of the Open Meetings Act. Do you have that available for?
Yeah, according to our agenda, it's section 10-15H3 to deliberate in connection with an administrative adjudicatory proceeding.
That's not a complete statutory citation. 1016.
Oh, you're right.
Yeah. I've got to get the number myself.
I can find it if we, do you have it with you there, Paul?
No, not in front of me.
It's 1015, chapter 10, section 15, 1 through 4. And so I'm not sure what section it's in, but hopefully that will help.
Thank you. Well,
Chair Miller,
Yes, Mr. Martinez.
the citation is 10-15-1 H3.
Okay, so thank you for that clarification. The motion is to enter executive session pursuant to 10-15-1 H3. The motion has been made and seconded. Any other discussion on the motion? Okay, can we get a roll call vote on that motion, please?
Yes, Member Amer,
Yes.
Member Biederman,
yes.
Member Kovnat,
Yes.
Member Lujan.
Yes.
The motion has been approved.
Okay, can Marcos or Christine, can you explain how executive session works in a Zoom context for all of our benefit?
Yes, Chair Miller, members of the board, what will happen, I will set up a separate Zoom meeting right now. I will email each of you the links, and then I will make another individual host. So our assistant city clerk, Ms. Cardenas, will stay on and keep this meeting open. We will return to this meeting after executive session to continue the meeting. So if you all would, yes, Member Lujan.
So during our executive meeting, who is it? Just the members? And I know that you, Madam Clerk, are hosting the Zoom. Does that exclude you? I'm just asking for clarification. Thank you.
We can have whoever we like at the meeting. I suggest board members, the city clerk, and council. I'm not aware of anybody else who needs to be in that session.
Thank you. Thank you, Chair.
Yes, and just for additional clarification, I do not participate. I simply mark the time, confirm the members that are present. I don't turn on my screen or participate in the communication at all. It's that is my role in the executive session, is to confirm the membership in the conversation, and then that is and to host the meeting separately.
Okay, so to just to be sure, we all leave this, or the members going into executive session leave this meeting, check our email, and open up a new link from you. Is that right?
Correct. I will exit this meeting now, and then you will receive a new link from me.
Okay, sounds good. And we will be back in this open meeting as soon as we can. Thank you.
I haven't gotten the new link yet. Have you, Paul?
No. Are we the only ones there?
I think so. Everybody else left.
No, Judith is there.
I'm Judith, yes, but she's muted.
I haven't gotten a link either.
Oh, okay.
So I'm just doing what I'm told, which is looking at my email.
I've been doing.
I am too. I'm looking at my phone.
There's a very pretty picture that says executive session with a wonderful sunset behind it. I don't know if that's symbolic of something.
Yeah.
While we're waiting, we can talk about non-related stuff. Are you guys getting? We got our.
Excuse me. Christine said, go ahead and exit this meeting, and the link should be going to your email right now.
Okay.
We should
Thank you.
Exit. We should
Will do.
exit.
Yes,
All right.
leave the meeting. There
Leave
you
me.
go.
think it's a miracle that I'm back in.
I think we're close to all back. Tara, are you in?
I am.
Okay. It looks like we're all here. First, we need to move to reopen this meeting. Can I have a motion to that effect?
So moved.
Okay, moved by Mr. Biederman, seconded
Second,
Ms. Kovnat. So the motion is to re-enter open session. Can I have a roll call vote on that motion, please?
Yes, Member Amer. You're muted, Judy.
Yes.
Thank you. Member Biederman,
Yes.
Member Kovnat,
yes.
Member Lujan.
Yes.
The motion has been approved.
Great. And just to state for the record, the board met in executive session for the reasons stated in the agenda and in the motion to enter executive session. No other matters were discussed in executive session and no final action was taken. So we are back in an open meeting, continuing the board's discussion on complaint 2021-1. So I open it up to the board for continuing discussion.
I make a, oh,
Go ahead, Ms. Amer. I saw your hand first.
I make a motion that we dismiss the complaint because it did not cite to a specific code provision that was violated.
Okay, thank you. There's been a motion. Do I have a second to that motion?
Second,
And a second. And now is there any discussion on the motion? Okay, I'm not seeing any discussion, meaning we will go ahead and vote. Can I have a roll call vote on the motion?
Member Amer,
Yes.
Member Biederman,
No.
Member Kovnat,
yes.
Member Lujan.
No. I'd like to explain my vote.
Okay, Mr. Chair, there is a tie.
Okay, then my vote is yes.
And Mr. Chair, I asked to explain my vote as well.
Okay, Ms. Lujan, please, you have the floor.
Thank you, Mr. Chair. I'd just like to state that there is a conflict of information in the way that we have our rules written in a technical concept of that, as opposed to the actual form that we have the public fill out. And I feel that that's something that needs to be remedied in order for us to have future hearings on our issues, but there is a conflict of how a layperson interprets what information they need to fill out on that form, as opposed to what is actually stated in technical language through our rules. And I feel that that we cannot, we need to take that into consideration when our public lay community members, and myself included, are filling out forms like this, and we don't understand a technical terminology and how to even to find it, locate it, and to actually interpret it. So that is why I am voting the way I did. Thank you, Mr. Chair, and thank you to everyone that's here today and is participating. And this is not easy stuff. This is not easy to do this, to even come forward with any kind of complaint like this, but also to understand, how things are set up. So I think that we can do a better job, and we need to do a better job of explaining to our public and having language that mirrors what we're asking in layman terms on a form that they're filling out. Thank you, Mr. Chair. That's all I have.
Thank you, Ms. Lujan. Mr. Biederman?
Yes, I agree with what Ms. Lujan just said, and especially about the importance of making our process inviting and easy for lay people to engage in without having to hire counsel to interpret some pretty complex provisions in the law or ordinances. And I'll add that I do, as I was suggesting before, I think we do have other areas in which the Supreme Court has approved some very general statements as to a claim, as in the magistrate courts, and that those general statements don't require the citation of statutes or case law, even though they might be brought to bear, but rather simply allow the inference that if a set of facts is stated that reflects a violation of the law, then in fact it is the role of the court to pick up on that and bring justice. And I think that's about the kind of thing that we do and we're supposed to do. So, and that said, by the way, I want to emphasize, while I see provisions in the law that I think are the ordinances that are adequately invoked here by the facts that were stated, that doesn't mean that my mind is made up as to whether those in fact were violated. I'm simply saying that a claim was stated, not that it was proven.
Thank you, Mr. Biederman. Any further comment on this matter? Okay, not seeing any, we will move on. Thank you to everybody for participating, and for the board for engaging in a fairly complex discussion, even though in some ways it may not seem to be. But this was a difficult issue, and thanks to the board for a thorough discussion and consideration of it. I appreciate it. We will now move on.
Mr. Chair, I'm sorry. Just one last thing. Did we specify that this would be a dismissal without prejudice? Did we have that, make that point?
No, we did not.
I believe that was the intention of the members who voted. Am I putting words in your mouth, or was that correct? To make the dismissal without prejudice?
I didn't understand that to be part of the motion, but you can state your thoughts on that. Just that I thought. Well, I'll leave it to the people who voted for the motion to decide that. Okay. That concludes this matter. Thank you to everyone. I'm going to move on to the next item on the agenda, which is item 5B, discussion of recommendation of legislation amending Ordinance 9-1-7F to adopt the Secretary of State's rules on resolving tie votes.
Excuse me, I apologize for interrupting, but Chair Miller, oh, there she is. I just sent Ms. Martinez an email letting her know that we were starting, so she's rejoining the meeting.
Oh, good.
Member Martinez. I just went into hold as she was literally joining there she is.
Okay. Welcome back, Ms. Martinez, and thank you, Christine, for doing that. I was moving on without thinking about it. So we're now on item 5B, discussion of the recommendation regarding an amendment to the ordinances for resolving a tie vote. As the board knows, this has been under discussion for the last couple of meetings. At the last meeting, the city said they would draft a relatively simple ordinance to accomplish what the board wanted to do. And we now have that draft that was provided to you. And we're here to discuss and take possible action on whether we want to make that recommendation to the governing body. So people have had a chance to look at that draft ordinance. Is there any comment or discussion about it?
I'll move adoption of the ordinance for discussion.
Okay, it's been moved by Mr. Biederman. Do I have a second? Seconded by Ms. Lujan. Marcos, maybe you can give us just a real quick summary of what the ordinance does. I think it's perfectly in line with what the board discussed last time, but just tell us how the drafting process went and what is in there.
Thank you, Chair Miller. As was discussed at the last meeting, this is another change that Common Cause has recommended the city adopt. They identified the fact that the Secretary of State's office had adopted a rule that purported to govern all elections that were using ranked choice voting. And this rule was specific to tie votes, or specifically addressed tie votes, much in the same way as the city ordinance had. And so it created the appearance of a conflict, at least, that I would prefer to avoid having to resolve in the situation that the city actually faces or finds itself in a tie under a ranked choice voting election. So the strikeout language represents the existing ordinance. It was really contemplated, or it goes back to the time when the city was not employing ranked choice voting. And so I would just offer for your consideration that the advantage that the Secretary of State's office's rule that implements a tie or how to resolve a tie at least has the advantage of using some of the information from other stages of the tabulation in a ranked choice vote. And so I think it can more easily resolve multi-party, multi-candidate elections that have gone through ranked choice voting. I guess I would leave it at that. If there's any other specific question I can try to answer, it's really just replacing one definition with another and how to resolve the tie situation.
Great, thank you. Okay, I'm not seeing anybody raising their hand to comment or discuss. If there is no further discussion, let's have our vote on this issue.
Member Amer,
Yes.
Member Biederman,
Yes.
Member Kovnat,
Yes.
Member Lujan,
Yes.
Member Martinez.
Yes.
The motion has been approved.
Okay, thank you. The next item on our agenda is a discussion of the 10th Circuit opinion in the Rio Grande Foundation versus the City of Santa Fe. Mr. Martinez, would you like to lead that discussion?
Yes, and at the outset, I want to apologize that the opinion itself did not make its way into the packet. we put this packet together on extremely short notice in order to try to make the complaint heard as soon as possible. But I just want to give a very brief overview of what happened, when it happened, and what has happened since the opinion is issued. So on August 3rd, and what I'll do is if I have the permission of the chair, I'll send to everyone on the board the opinion for your convenience, and we'd be happy to discuss it further at future meetings. But the 10th Circuit basically issued an opinion on August 3rd, and the opinion dismisses the Rio Grande Foundation's appeal for lack of jurisdiction. The basis for that lack of jurisdiction was, in the 10th Circuit's opinion, the inability of the plaintiff appellant to show that they had standing to sue in First Amendment cases that they characterize as a chill case, where regulation allegedly chills the First Amendment rights of someone who wants to speak about an election-related issue. The 10th Circuit relied on a 2006 opinion out of this circuit called Initiative and Referendum Institute versus Walker, which articulated the test for prospective standing required in chilled speech cases. And so there's basically a three-part test, and the opinion focused on the fact that the foundation had failed to satisfy the third prong of that test, which is that they would present a plausible claim that they presently have no intention to speak because of a threat that a statute forbidding that speech would be enforced. In other words, in the case of the Rio Grande Foundation, they have not pled or they have not alleged or claimed that they have no intention to speak in future ballot proposition measures because they're afraid that the statute would be enforced, the statute being the disclosure requirement for independent expenditures. And rather what they said was that they do intend to speak, and that should satisfy the standing requirement. In other words, they shouldn't have to be so afraid that they would not speak, but for the threat of prosecution. So that's kind of a general overview, and I'd be happy to answer some specific questions about the opinion. The opinion is only 9 pages. It's not very long. What has happened since then is that on Tuesday, the Rio Grande Foundation filed a petition for rehearing, or a rehearing en banc, however you pronounce it. And on Wednesday, yesterday, the court ordered the city to respond to that petition for rehearing, which under the rules, under the 10th Circuit rules, is not at least a process that is contemplated by the rules. In other words, normally you would do a petition for rehearing, and the court would take it under advisement and determine if a rehearing was appropriate or not. In this case, they want this to give the city an opportunity to respond. And so we're now looking at the petition for rehearing. And I guess with that, I would just pause. Again, I've spoken about the case and made some specific representations. You don't have the value of the case before you, or you don't have the opportunity. You may not have had the opportunity to read it, so I apologize for that. But I will be circulating that, and we will have, I'm sure, future meetings in which you can ask any questions you have. There may be more developments in those future meetings, and we can talk further at that time. And now I'll stand for any questions.
Great, thank you for the update. Any questions from the board?
Maybe just one comment, Mr. Chair, and that is that I suppose that if the request by the full court for briefing from the city that is unusual, that might mean that they want to get to the merits. Now, that doesn't say what the outcome would be if they get to the merits of the case, rather than decide to dismiss it on the procedural grounds that they dismissed it on, the standing grounds, actually. it's just a thought on my part that if they do decide to rehear it, we may be getting down to the nitty gritty of the facts, and that might not be a bad thing to resolve, hopefully in our favor, though. Just a comment.
Thank you, Mr. Biederman. And I would say, two things might affect the litigation. Some of the amendments that this body has recommended might change some of the factual allegations that the Rio Grande Foundation is making. For example, they continue to repeat the fact that if you spend a penny independent expenditure, you're going to have to disclose that. This board has made a recommendation, and the governing body of the city is now considering an amendment to the code that require a minimum spending of $25. And also the threshold has been raised to $500. So again, the case or the law, both in terms of the positive law that the city is promulgating and in terms of the case law is evolving. So it's an interesting area.
Thank you.
Yeah, thanks. To follow up on that, I think the narrowness of the 10th Circuit's opinion really didn't resolve the issues that this board dealt with in trying to decide about the appropriate limits under the ordinance. So I think our recommendation to the governing body and the progress of those changes, I think, proceeds and is not really affected by this decision. So I think we were ahead of the game on that, at least. So. Okay. I think that's it. Any further comments or discussion? Okay, then moving on to item 6, matters from staff. Are there any matters from the staff?
I have no matters at this time. Chair Miller, thank you.
Thank you. All right. Item 7, matters from the committee. Are there any matters from the committee?
Mr. Chairman, just the fact that we just got a new complaint that has not been responded to yet. Maybe this falls under 9.
I was thinking of talking about this under 7, 8, or 9, so I'm glad you brought it up.
Okay.
What Mr. Biederman is referring to is the filing of the new complaint that I think everybody has, everyone has received it. If you've all had a chance to look at it, here's a question for the city. Has the complaint been sent to the respondent and the respondent's been notified of the 10-day period to respond?
Chairman Miller, members of the board, we did. I notified all 3 organizations via email. However, 2 of those email addresses were, we received a bounce back. So they were printed and hand delivered to 2 of the organizations this afternoon. So that will trigger the 10-day. They were also provided a copy of the ethics, organization rules, the guidebook that dictates the 10 days so that they're aware of that with reference to exactly what section they need. We're referencing. So those were delivered. Again, the 2 were hand delivered to the organizations that did not have valid email addresses this afternoon. And then they have their 10 days to respond from that. So we can go ahead and find, that's that. I'll wait until we go to next meeting date to further any discussion on that item. But to answer your question, yes, 1 was served yesterday and 1 was provided today. Or 2 were provided today, I'm sorry.
Mr. Chairman, I misspoke before when I said the city's response. I meant to say the defense. I didn't want to confuse people. Yeah.
Right. Okay. Well, the next thing, I guess the next question is when we can meet. So maybe we'll just, I know we're on item 7, matters from the committee. Are there any other matters? Paul, can we continue this part of your matter at the next meeting matter?
What's that?
Sorry.
I don't think I understood your question.
Yeah, we do need to talk about it.
Yes, you can. Now I understand your question.
Okay, sorry. Okay, no, are there any other matters from the committee? I'll just put it that way. Yes, Ms. Lujan?
No, this is exactly a matter, but just as we're coming to a close of our, not quite yet, but almost to a close of our meeting today, just on the note that we are discussing interpretative information to the public and just making sure that if we're getting those questions, or if they're going to come, that I just got a question about whether the first complaint we heard today and we voted on could be sent again and remedied in a fashion that would be different from the first. If it could be resubmitted, I guess is the question. And I just wanted to address that and say, yes, it could be resubmitted in a different fashion. And that just goes back to someone not understanding a determination with or without prejudice. So I think I lost you.
No, we can still hear you.
Can you hear me? Oh, okay. So I just think that someone was just asking for clarification and not understanding why we spoke about prejudice, with or without prejudice, in our vote. So I don't know if we want to discuss that, or I just wanted to say, yes, it can be resubmitted and just address it right now. That's all. Thank you, Mr. Chair.
Okay, any other matters from the committee? Okay, I'm not seeing any matters from the chair. I don't have any matters to bring up. So item 9, the next meeting ties back to the conversation about the complaint we have just received. I guess by my calculations, if the notice was sent to the respondent yesterday on the 18th, then their response will be due September 1st. So we could schedule another meeting anytime after that. We could talk about a date that would work now, or we could just sort of follow our usual process of having the city send out some possible dates and getting responses from the board.
Chairman Miller, if I may, my staff, we had done the calculations for packet to meet noticing and agenda deadlines as well, based off of the 10-day. Keeping consistent with Thursday afternoons, I could recommend the 9th, September 9th. That was going to be my proposed date for this agenda item. Same time, if that was the desire of the board.
Yeah, thank you for thinking of the notice. I'm just looking at my calendar, and I think the 9th would work for me.
Yeah, the 9th would work for me as well.
The 9th works for me.
Okay, for me too.
Okay, I'm not sure because of a medical thing that I don't have a time for yet. But I think if you go ahead, there's a good chance I'll make it, but I can't promise.
I'm not sure with as well, but if you schedule it and we have quorum, I think that's great. But I'm just not completely sure with my schedule. Thank you.
Good. Well, let's go with the 9th, at least tentatively. And Paul and Tara, if you find something that definitely is a problem, let us know soon, and we can get that finalized before too long. So that's great.
I think it'll work. I'm just not certain yet.
Okay. On to item 10, adjournment. Do I have a motion to adjourn?
So moved.
Moved by Mr. Biederman, seconded by
I second that.
Ms. Kavanagh. Okay, and the final thing is a vote on the motion.
Member Amer,
Yes.
Member Biederman,
Yes.
Member Kovnat,
Yes.
Member Lujan,
Yes.
Member Martinez.
Yes.
The motion has been approved.
Okay, thanks, everyone.
Thank you.
Thank
Good meeting, Mr.
you.
Chairman.
Thank you.